Morning, Mr. Moon.
Morning, Chief Justice. My name is Mike Moan, and I represent Judge Murphy. I would like to address you on 4 matters this morning. That is the issue of recommittal, the issue of willful misconduct, the issue of the appropriate sanction for Judge Murphy, and lastly, the so-called secret file that the Commission used in this matter. First of all, let me address you on the issue of recommittal. This requires me to talk in code, but let me try to talk in code as I can. You have before you impounded material that is the basis of my motion to recommit this matter to the Judicial Conduct Commission.
Mr. Moe, let me ask you this. Do you have an affidavit from a doctor that says that this, the subject of the report couldn't have been determined or be known by the time of the hearing?
Could not have been known.
I said, do you have an affidavit from a doctor?
How could I get such an affidavit? No, I don't. I did not know it, and
Well,
nobody could have known it. That material.
What I'm asking, do you have an affidavit? I know you say nobody could have known it, but
Well,
I'm asking you if you have an affidavit from
if
a
you-
doctor that says.
No, of course I don't have an affidavit from a doctor.
So
If
why,
I had
why,
time.
if you take a look at it from the just the traditional rule of newly discovered evidence, why is this newly discovered if it was something that was knowable by a professional at the time,
It
not
was-
a legal professional?
It was absolutely contrary to the opinions of the doctors who were treating Dr. Murphy at the time.
But why isn't
Judge
it-
Murphy.
I'm sorry, why don't you finish?
Judge Murphy. So you had opinions about Judge Murphy's mental state, but that opinion is totally different.
Yeah, but
and I
It's different, but could if you had gone to see that doctor at that time, would he have given you that opinion at that time?
I suppose if I had guessed that there might be something out there, I suppose that is possible. But you're talking about sanctioning a judicial officer here.
Well,
You ought to, in determining whether or not to sanction him, you ought to take into account something that goes to the heart of the finding of willfulness. You at least ought to ask the Commission to consider it.
Why isn't this a case of this particular issue that Judge Cowan raised? Why isn't it just a question of old clothes, new tailor?
It's entirely different. If you've read the report, I know because I've gotten a copy of a letter from the Commission to the Commission. We're talking about it. You've read it. That talks about a condition that not only was not known to me, but is totally different than the condition.
You might not have had a basis for knowing, but didn't you have a basis for inquiring?
No. If I had, I would.
Are the letters, letters that accompanied Judge Murphy's request in July of 2007 to the governor for disability?
Yes.
And included with those were, I think, maybe two letters of two psychiatrists.
Yes. No, it's one letter.
One
It's two.
doctor.
It's one doctor.
One doctor.
One internist, his internist
that's right,
and
that's right.
psychiatrist.
Are those letters included in this record at all? It just would be, because they're referred to, and I know they're not impounded, but I'm just wondering if we have them.
No, they're not included in this record, but they relate to the stress disorder, which everybody always knew about. This court found
no, I know
existed.
that.
Could you send them in?
Yeah, I would just
Of course
like
I'll
to
send
see
them
them.
in. But they're totally different.
I appreciate that fact.
Okay.
That's just what I want to see. That.
Another fact question that I have, and maybe you could enlighten me. You refer, and the board refers, to this letter from Jill Pearson from 3 years ago, but nobody really tells about the appropriateness of using judicial stationery for court business. That's a quote from one of the briefs. But nobody, or at least I shouldn't say nobody, I haven't. Could you just tell me exactly what the letter said
Sure.
and what was the
I can tell you.
genesis of
I
it, so
can
have a better
tell you.
idea?
I can tell you what it
Just so I
said.
understand, Mr. Moon, this is the 2001 letter?
This is the
2002.
yes. This is the
2002.
in 2001 as a result of the Herald stories. Someone complained about a person complained about Judge Murphy's conduct. Judge Murphy replied to that complaint on judicial stationery and said essentially that there are two sides to this story, and indeed I'm going to bring a libel action about the other side of this story, a libel action which of course he brought and then won. So that related to the Herald story, and it related to his reply on judicial stationery to a complaint about his judicial conduct, and he replied on judicial stationery. It was not for some private gain. It was not about a private matter. It was about a controversy that he was intimately involved in at the time.
And by
And
the
then what did
way,
her letter to him say in reply?
Now that I believe it said, now that I understand it, I have a different view, but I don't remember exactly. That correspondence is available.
It's
Yeah.
not, but it is not.
It's not in the record.
It was
And
not.
that's why I was
It was not
wondering.
in the record, and perhaps a mistake on my part that I didn't put it in. But remember, the judge didn't take the letter from Jill Pearson itself.
No, but you see, it may be relevant to whether Judge Murphy knew anything later on about using judicial stationery. And the letter wasn't in the record, so I didn't.
Well,
And her
I can
original
submit the
letter
letter.
to him, I assume then her original letter to him said something like it isn't appropriate to use judicial stationery.
And then
I think it
responded.
was not. It was couched in different terms. It did say that you ought to consider about the use of judicial
can you
stationery.
send it in?
Yes, of course.
Mr. Moran, Judge
Yes.
Slaney, go ahead.
Well, while we're on facts, I find this extremely troubling from the Commission's point of view, or for the Commission, if it's true. At all material times, was there anything at all in the Code of Conduct, either in the rules themselves or in the commentary, about using judicial letterhead?
I think there was a reference in the commentary, but there was never a specific prohibition in the rule itself.
Was the reference in the commentary at the time that Judge Murphy wrote the letter?
I believe it was.
It was.
Yes, it was. It was, but it was not a part of the rules.
I mean,
And
the letter, the
incidentally,
letters that we're worrying about today, or the letter on the other letter you talked about?
that was the earlier letter. I believe at that time it was just in the commentary.
It's Ms. Pearson's first letter was 2002. The code with the commentary was effective October 1, 2003. The letters we are talking about are February and March
Right.
of 2005.
Right. But I think in fairness to the fact that if a judge used judicial stationery to really inject his judicial position into something where the other side didn't know, if you have a dispute with your plumber and you write him back on judicial stationery, I think that's an entirely different matter. That's not what happened here. This is a situation where the whole Murphy case arose out of his service as a judge. Mr. Purcell's could not possibly have been surprised when he got a letter indicating that Judge Murphy was a judge, a justice of the Supreme Court. By the way, he has apologized from the very beginning for the use of that letterhead. He's
Moore.
apologized for it, an apology we've never heard from the Herald, incidentally.
Mr. Moran, could I ask you a separate question? As I
Yes, of
understand
course.
it, the hearing officer found no willfulness, correct?
Yes, he did.
The commission found willfulness or concluded willfulness, correct?
Yes.
Could you tell me how I am to review what the commission does with respect to the judges? And I'm going to ask counsel for the commission the same question.
I've been here twice in these matters. I think you've had 3 of them. I've been the lawyer standing here twice. I was the lawyer in Markey, and I'm the lawyer now in Murphy. They don't get assigned alphabetically, but I've been the lawyer in both of them. Now listen, in both cases, before the case was ever tried, before the hearing officer ever heard a word of evidence, the commission had a sanction that they wanted to impose. And in both cases, the hearing officer found that that was not appropriate, found that the judge should not be sanctioned in that manner, and the commission just simply ignored him and made its own findings of fact, changed findings of fact, and came to its preordained conclusion.
Well, I think before we even get to the sanction, and I understand the point you're making, and it's bothering me, I think it's the same thing that's bothering the Chief Justice, which is that we have a hearing officer. The hearing officer makes a finding, which is a finding of fact based on credibility. He believed Judge Murphy.
Right.
He said it wasn't intentional, it wasn't willful,
Right.
blah, blah, blah. Then how does the commission get to go and reverse a finding of fact? And I don't understand
Not only a
that.
finding of fact, but a finding which is in essence a credibility
Well, that's
finding.
what I just said.
Right,
It's
I
a
know.
finding.
And so that even in situations where you have cases where somebody can go, for instance, the Board of Bar Overseers, a hearing committee, the Board of Bar Overseers can reverse a hearing committee on some matters, but not on a credibility finding. Not on a credibility finding.
I'm
Well, that's
waiting
what I
for the
don't
commission
understand.
lawyer to tell me what case says they can change findings of fact.
Yeah,
The statute says they can change conclusions. That's an entirely different thing. Those are conclusions of law and so forth. But what case says they can change findings of fact?
And specifically,
I don't know of any. Do you?
No, specifically in this case, Judge Kilbourne found that he did not have the intent that they found that he had.
Mr. Moen, is willfulness for these purposes legal or factual?
I think willfulness is an issue of both. It's a mixed question of fact and law, I think. I think willfulness has to be put together with the misconduct. Obviously, if you write a letter, that's an act, that's a willful act. But if you put it together with misconduct, that's an entirely different thing. And that's the finding that Judge Kilbourne, who sat on this case, who heard the parties, who looked the parties in the eye, who listened to Judge Murphy, that's the finding that he refused to make. And I think that's very telling.
You made a quite serious statement that the commission had a sanction before the hearing officer was appointed. They had a sanction in mind. Is there anything in the record that supports that? I mean, is there a letter that says?
No, they tell you before you start. They told me what he essentially the plea bargain was.
Well, that's.
I didn't accept it, so we have the hearing. The hearing officer finds in the other way, and we go right back to that sanction. That's not a system of justice, frankly. That's a Potemkin village.
Well, that's not so different from what happens in cases all the time. I mean, you have a plea bargain,
Right.
Plea negotiations.
Right.
You don't accept the plea, you go to trial, the judge imposes what, the prosecutor would have recommended.
But only if there's a guilty finding.
Oh, of course.
There's a big difference.
Well, but
This is where
Right.
there has been a
Well,
finding the other way.
Right, well, that's why I
It's
asked you the underlying question.
entirely different. A judge can't say to a defendant or his defendant's lawyer, look, if this goes to trial and you don't accept the prosecutor's offer of a plea, I'm going to sentence you to what the prosecutor wanted. We know you can't have that.
No, but I don't think that was said here either.
No, what is
No,
said?
but here, the fact finder, namely the ultimate fact finder and penalty imposer, the conduct commission, is the one making the offer. They're both the prosecutor and the fact finder.
And the way this works, the adjudicator at the end of it.
And the adjudicator
So
at
I mean
the end. So
that whole
it's
process.
totally different than what goes
That
on.
whole process is this is one of those systems that looks fair if you look at it, but in actuality is not. And what does it say to the hearing officers that you appoint?
Mr. Moen, let me ask you this question.
Yes.
Following up, it's a mixed question of fact or law, and with some reference to the BBO, where something is our jurisprudence with lawyer discipline, as you know, if there's a clear finding of fact that the lawyer transferred $5,000, into a non-IOTA account or something like that. Even around that, we may quibble as to whether we have to accept that if there's clear evidence to the contrary. But if we were to look at this record, leaving aside the commission, we look at the record that was before the hearing officer, can we conclude for ourselves that there was willfulness here? And that may go to your fourth point.
Not on this record. I don't think you can
Okay.
conclude that.
Can
at
we
all.
look at that question?
What?
Can we look at that question?
Ultimately, you can do almost anything you want, but you
But how
shouldn't.
can we if there's been a hearing officer? Otherwise, what is the point of having a hearing officer?
That's my
It's just
point.
spinning your wheels. And
That's my
wasting
point.
everybody's
I'm
time.
involved in a
It's just
long
like
process.
It's just like a judge or a jury. They make a finding of fact. We can't reverse it unless there's not enough evidence to warrant that finding.
Right.
And unless
And in this
the
case,
record
there
is
was
devoid of
more
evidence,
more than adequate evidence to warrant
well,
his finding.
his own
But
testimony.
we are dealing with a statute that is peculiar in many ways, and so the role of
To say the least.
to say the least.
Yes.
So the role of the hearing officer vis-a-vis the commission on fact-finding really does have a statutory base. I'm not saying anything about this case, but I think you can't totally analogize it to anything else because it really is sui generis.
Well, it is, except that you have to look at other kinds of cases, and particularly when you're dealing with a standard of clear and convincing evidence.
I agree.
You have to look at what the hearing officer found, because otherwise that's a sham hearing. If we just go, if they can do what they want after they because largely speaking, the facts in the case were not largely in dispute. What was in dispute was exactly the issue that this hearing officer found, which were two important things: that he did not intend to intimidate the Herald, and that the Herald was not intimidated, and
Right.
that he didn't intend
Well,
to
the
reject.
commission found that also, that Mr. Purcell was not intimidated or threatened.
Except that they go back to.
I know what they say, but that is a factual
Right.
finding
I
number
understand that.
51, and there it is.
I understand that, but they go back to a letter that was never in evidence, and they go back to an agreement that we had that nothing his lawyers would be used against him, and they used that letter to say that his lawyers and Judge Murphy were attempting to intimidate the Herald. That just shows the bias in my
Mr.
view.
Moen, could I ask you to address sanctions?
Sure. You know, I guess to analogize it to the Board of Bar Overseers, you know, sanctions have to have some kind of consistency and rationality to them. And this court has never sanctioned somebody with a suspension unless their conduct involved dishonesty. There's been no finding that Judge Murphy did anything that was dishonest. They have never sanctioned a judge whose conduct did not involve corruption of the judicial process. I was here last time with Judge Markey. What did Judge Markey do? They say, well, he just made a phone call. Now, wait a minute. He made a phone call that changed the judge's determination in the case, an ex-party conversation, and he was also
Well, it affected. We don't know that it changed it. It affected it.
She went on the bench and said it did. So there was no question about
Are
it.
you saying the commission, or you say, I mean, because there are agreed upon dispositions that have included sanctions more than this, where no dishonesty was found.
Oh, but they all involved cases, because I put that in my, there's an appendix that you have. Many of those cases I was involved in. All of those cases involved very, very serious conduct. They involved conduct on the bench, in most part, or involved conduct of corruption of the process, ex-party conversations. Several of them are ex-party conversations. Orfanello, which is a Board of Bar Overseers case, that's an ex-party conversation with a judge about what he was going to do in the case. So they are much more serious cases. This is a situation where Judge Murphy acknowledges that he made a mistake, acknowledges he shouldn't have written the letters, but he didn't, you know, it was not for private gain. And, you know, one of the things they make is, well, he asked for too much money. He actually asked for $200,000 less than they ultimately paid, plus $1 million in legal fees. That's what happened. So, you know, that was bad tactics. It was bad strategy. But it wasn't corruption of the process. And it was purely extrajudicial. Judge Murphy is not being charged with anything that he did on the bench or anything that he did to affect the judicial process in the case. I see I've got blinking lights, and I'm not sure exactly what they mean.
I think it means
Time
you
to
stop,
stop.
which is why I looked to see if my colleagues had
Time to
any other
stop.
questions,
Thank
but I
you very
don't
much.
believe they did. Thank you, Mr. Moen. Mr. Neff, good morning.
Good morning. May it please the Court, Howard Neff for the Commission on Judicial Conduct. Since it came up as an important issue at the outset, I wanted to begin by addressing the question of the recommittal of the case. And I would respectfully disagree with Attorney Moen's characterization of how that presents itself to the Court. As the Court is well aware, at least in the bar context, issues or claims not presented during the course of Board of Bar Overseer proceedings are deemed waived if not presented during the opportunity.
If you didn't know it, and you couldn't, let's just assume for your theory that you couldn't know it, how could that be the rule?
Well, I would question whether this Court would want to adopt that same standard applied in other cases to judicial misconduct proceedings where there are more opportunities for thought and reflection on what the possible claims and defenses are. But I would, in that sense, also disagree with Mr. Moen's characterization of what's presented here to the Court today. He seems to have suggested that the Court can now consider the document in question. The Commission is certainly aware it's before the Court.
Doesn't it make a difference, Mr. Neff, when we look at this concept of waiver, that we're not dealing with a products liability case where, for example, if you didn't know a screw was not tightened the right way and that's why the whatever fell down, or you did know, you know, and that's fairly stark on whether there's waiver or not waiver. You're dealing here with a subject matter that requires highly expert testimony. And the highly expert testimony that's in the new information that's been supplied didn't come later. It's not in the earlier material at all. Entirely different doctors.
Well, I don't think that I would respectfully suggest that variety of difference doesn't preclude the possibility that investigating possible...
Doesn't include the possibility, but as a practical matter, does it show waiver?
I would respectfully suggest that it does. In judicial misconduct proceedings, Judge Murphy in this case had a number of opportunities to investigate and think about and explore possible defenses he would present in this case. When he got the complaint, he could have responded. He could have answered the statement of allegations with this kind of defense. He could have answered the formal charges with this kind of defense. And he could have presented this defense by way of expert testimony during the course of the formal hearing if he hadn't already done so.
Mr. Neff, you heard Mr. Moen say several times that the information that was received after the hearing officer had made his report and after the commission had made its determinations were totally different. What in the record supports a statement by counsel that they are totally different?
I would respectfully disagree with that characterization as well. I'm assuming at this point that the document in question is going to be coming before the court with respect to this case for review. I would therefore respectfully suggest there are two problems with that notion. First is that the document in question, while it speaks to Judge Murphy's status in the present tense, there's nothing in the report that has been presented and will be before the court on this case that speaks to, and in terms of relevance, speaks to what his status or state was in February and then in March of 2005 when he wrote these letters.
Don't you think, I mean, I'm not a doctor, but my reading of this is that it's not some late blooming condition, that it is indeed something that would have existed at the time as well.
Well, I would not necessarily disagree that exists as a possibility. However, I would respectfully suggest that at this stage the burden would have been or is on Judge Murphy to present that defense or claim, that he hasn't presented that defense or claim, and for him to now, based on evidence of questionable relevance, to now suggest that the court take this extraordinary step of sending back to the commission a case that has gone through all these procedural steps over the course of a long period of time. I'd suggest that the evidence is not there to justify that kind of drastic action. I would also respectfully suggest, to get back to Justice Graney's issue, that even if the court were to say, okay, in fairness, Judge Murphy, Attorney Moen had no idea that this was an issue at all, had no reason to present this because it was a completely different issue than what had come up in 2002 and really in 2007. I would respectfully disagree with that characterization by Attorney Moen of this document as well. The document itself is preliminary. It makes some conclusions and findings. It proposes some possible causes of certain behaviors, etc. But there's nothing, I'd suggest again, that conclusively establishes in a way that makes it relevant enough in this case that the causes of whatever the doctors observed and put into this document are any different than the issues to which both Judge Murphy and Attorney Moen were clearly alerted back in 2002.
Can I change the subject a little bit? I think we've sort of covered the waiver thing. Do you have any cases you can cite that permits the commission to change a hearing officer's findings of fact that are based essentially on credibility?
Well, I would respectfully suggest that a lot of that authority is pretty explicit in Chapter 211C, but to answer that direct question...
211C says you can change conclusions, doesn't it?
Well, it does, but the question then becomes, in Chapter 211C, what is the definition of conclusion in that context? Reading the rest of the statute respectfully, what Chapter 211 quite clearly states is what the hearing officer presents to the commission are proposed findings and recommendations. Chapter 211C then permits counsel for the commission and counsel for Judge Murphy to present to the commission objections to both the findings and recommendations of the hearing officer in this case. And I would respectfully suggest that reading that statute as a whole, it really wouldn't make sense to say the counsel for the commission and counsel for Judge Murphy can object to the hearing officer's findings, but the commission's hands are tied. They can't do anything to sustain.
But then what is the purpose of the hearing officer?
Yeah.
If the hearing officer hears the witness, Judge Murphy, and finds that, and believes Judge Murphy, and finds that there was no willful misconduct, then how can the commission reverse a finding that's based on credibility?
Well, I would say that, as Justice Botsford pointed out, there's some sort of oddities to the way Chapter 211C is constructed and the way the Commission and various other entities that interact in judicial misconduct cases sort of are intertwined with each other. I would just respectfully say that the way the statute's laid out, there's a hearing officer, he hears evidence, makes findings and recommendations to the Commission. In the present case, the Commission did in fact adopt most of the hearing officer's findings and recommendations to the Commission in this case. With respect to that issue, the Commission respectfully disagreed, and I respectfully...
But on what basis?
Didn't adopt
not having heard the witness, how
didn't it?
how can the Commission disagree? It
Yeah.
has to have a reason. I mean, you have to say the finding is not warranted.
Well, the statute is the platform, I'd suggest, from which the Commission has authority to do that. The statute does say the Commission shall state findings and conclusions in support of that. And what the Commission did, well, respectfully, the case I was going to get to is matter of Markey. And matter of Markey, basically the same procedural set of facts took place with respect to the triers of fact. The case was presented to a hearing officer. Judge Markey and Judge Murphy both denied that their misconduct was intentional. The hearing officer in both cases found that the judge's misconduct was not intentional. In Markey, the judge found that the judge was telling the truth, that his misconduct was not intentional. The Commission respectfully disagreed in that case, found that there was a strong and reasonable inference to be drawn.
Don't you think that in that case it really comes down to the Commission finding and the court agreeing with this blinders, you know, would have had to have blinders on, that it was a clearly erroneous factual finding in Markey?
Well, I would say that that's not the standard that's stated in Markey. What appears to have been said respectfully in Judge Markey is that explicitly in that decision is the facts, the Commission's review of the evidence and of the hearing officer's findings permitted the Commission to draw a strong and reasonable inference manifestly justified by the evidence that in fact Judge Markey's misconduct was intentional. Now, it's of course a question for this court whether you agree with the reasonable...
Okay, accepting that, how here would it be reasonable for the Commission to have found willful misconduct?
Well, I would respectfully suggest that in drawing a reasonable inference in a case like this, the Commission could do in this case exactly what appears to have happened in Markey, which is it employed its collective common sense. And I'd respectfully suggest that in the professional world, people understand that using the official stationery of their agency, business, institution, when you put words on that piece of paper, they carry additional weight or authority that comes from the agency or institution.
So, as Mr. Moen said, when you're dealing with your plumber. But when you're dealing with a person who's a publisher of one of the two major newspapers in the city, and when the whole genesis of the issue is the fact that Judge Murphy is a judge, how can the fact that the man writes on judicial stationery make any difference?
Well,
I mean, as far as intimidating or threatening or throwing your weight around or whatever you want to say.
I would respectfully suggest that Judge Murphy's letters in February and March reflect, I would suggest, extremely poor judgment on his behalf. So to find...
Maybe it is poor judgment. But maybe it was poor judgment to use the stationery, but was it willful misconduct? I mean, how can the evidence support finding that it was willful misconduct, given the whole context of the situation?
Well, again, that's the reasonable inference the Commission draws. And so the question becomes, in this case, Judge Murphy is an experienced judge. He has a code of conduct. At that point in time, the commentary to the code told him explicitly that you can't use judicial stationery for personal reasons. He had, at that point in time, previously gotten a letter from the executive director of the Commission advising him about proper use of judicial stationery. And notwithstanding those facts, chose not to write just a benign personal letter to his plumber, but chose to write a letter on official court stationery expressing a legal opinion to the opposing side in a multi-million-dollar lawsuit he himself had filed, and from which he was personally going to benefit. I would respectfully suggest...
Did his lawyers know about it?
Attorney Cooper testified that he did not know until the Herald made that
the letters
public.
had been written?
Mr. Neff, could I ask you a question?
Yes.
The letters, the correspondence between the executive director of the Commission and Judge Murphy, that predated the earliest letters.
That's
Were
right.
those introduced in evidence before the hearing officer?
In part, they were. I know there were questions directed to Attorney Moen on this subject, so I guess expand a little bit on the record that's before you. I would tell you that although it's not completely clear from the transcript, when I started to ask questions and attempt to introduce those letters, which I tried to introduce, we had a sidebar conference with Judge Kilbourne where he gave me very strict instructions on what I could and could not present. My intention had been present an entire course.
They were not admitted in evidence?
They weren't. I actually did make that attempt. Judge Kilbourne didn't allow me.
Did you take an exception to that ruling?
Oh, I don't think you ever
No.
offered them, did you?
I did. They were offered. It was a bit of a tricky situation because these
But
were.
You have no argument in your brief that they should have been, it was error to exclude them, so
No.
that's not
No,
really
that's-
before us. Can I ask you, well, go ahead.
Follow up, because as I read 211C Section 7, subparagraph 8, I agree it says proposed findings and recommendations, but I take it that what the hearing officer submits with his or her proposed findings and recommendations is a transcript of testimony and all exhibits, correct?
That's right.
And so I take it that that was the basis of the commission's then, in essence, de novo, whatever you want to call it, review. If those letters were not in evidence, and if you had not taken an exception, and had not pursued the point, how can the commission have relied upon those letters?
They did not, Your Honor.
So-
Judge
They
Kilbourne
didn't.
actually
The only
referenced-
part. I'm sorry. I didn't mean to.
I believe Judge Kilbourne's report references that August 02 letter as well.
It does.
It does.
Right.
The only aspects of those letters that were before the commission during their deliberations, actually before and considered by the commission
some
during their
kind of
deliberations,
notice?
was what was presented during the formal hearing. And
Testimony about it. The
well,
testimony about it.
the
Right.
testimony about those letters
Essentially
during the formal
notice that
hearing.
the judge had notice, that this particular judge had specific notice
Not to use letterhead.
not to use letterhead or to be cautious about using letterhead.
Yeah.
Judge Kilbourne, the hearing officer, was presented with that.
Before your
exception.
time runs out, maybe Mr. Moen can confirm this in a letter, and this is not, in case we get to this point. If we find that the commission went beyond its power in changing Judge Kilbourne's findings of fact, and perhaps also if we find either together with that or separately that the sanction that the commission imposed is unwarranted in light of the cases that were discussed earlier, as I understand it, is it still your understanding that Judge Murphy's willing to accept Judge Kilbourne's recommendation, which is a reprimand?
Well, that seems to be what he said.
And the answer is yes. But we could not. We could unilaterally impose that, or do we send it back to the commission and say, now you reconsider this?
Reconsider the
Whether there
recommended
should just
sanction.
be a reprimand.
I think at this procedural stage, the hearing officer made his recommendation. The commission made it.
So the whole thing is in
the
our
statute. Yes,
is
the
on our
statute
desk.
calls for transmission of the
Okay.
whole record, including the hearing officer's
Okay, and
report.
Mr. Moen, I think, just expressed his agreement that the reprimand would be accepted.
Right.
Mr.
I
Neff,
of course would respectfully suggest.
I know
Okay.
you're arguing
Okay.
against it.
Mr. Neff, as I asked Mr. Moen, could you address the question of sanctions, taking into account the prior instances in which this court has imposed a suspension and a substantial fine? As I take it, the fine would essentially amount to an additional, month or two of a judge's pay.
Well, in formulating a recommendation for discipline in this case, Your Honor, the commission paid a lot of attention to the case matter of Markey, where the court, as I suggested in my brief, basically suggested there's a threshold of misconduct so serious that nothing other than suspension is appropriate. Contrary to the suggestion that matter of Brown is analogous to the case before the court today, I would respectfully suggest that a case where a judge, I would suggest where a case where a judge has used his stationery and used his judicial title to pressure and intimidate someone into settling a case and into settling for what amounted to an excessive settlement figure as of that time, where judges accused and found to have committed misconduct in that form, I would suggest that rises to the same level of misconduct as was present in a case like Matter of Markey.
If we, and again, this is an if we conclude that the reprimand should be the sanction, that moots out the motion to recommit, does it not? It moots the motion to recommit.
Well, that might have the effect, although I would respectfully suggest that shouldn't be the reason why the reprimand is imposed.
No. But if we conclude on the whole record the reprimand is the proper thing, which he wanted to, he agreed to accept in the first place, there's no need to recommit.
That may be true, although, again, respectfully, I would suggest that
No,
probably
I
is not a
said
proper
if,
reason to.
If we conclude.
I would agree with that.
Mr. Foxwood?
When you speak of willful misconduct and the letter being threatening and intimidating, do you consider it totally irrelevant that the commission specifically found that Mr. Purcell was not threatened or intimidated?
I would not. As I stated in a few different instances throughout the record of this case, in cases of judicial misconduct, what matters is how would a reasonable person react
But we're dealing with a real live human being to whom the letter was addressed, and the commission says he wasn't threatened and he wasn't intimidated, and I don't see why that is not relevant to this.
Well, I think it could be relevant as an aggravating factor, but again, the way historically in this state and in other jurisdictions judicial misconduct has been approached is how would a reasonable objective observer react to the misconduct of the judge? And the commission, notwithstanding their findings specific to Mr. Purcell, concluded that a reasonable objective observer would have been intimidated by these kind of letters from a judge. And in this case, I would suggest that no more than we could punish or suggest punishment for Judge Murphy that's more severe because Mr. Purcell was particularly susceptible to these letters, should it count to his benefit that Mr. Purcell is who he is and was particularly resilient to the particular type of intimidation.
What case says that the commission standard is the reasonable objective person standard and not what the actual facts are? Is there any case that says that?
Well, there are cases in other jurisdictions.
Oh, but none here.
No, there are no cases in this
Okay.
jurisdiction on that.
One way or the other.
That's true. That's true.
Thank you, Mr. Mayor.
Thank you.
Here